Hello and a warm welcome to This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court has notably ruled that once a document has been admitted in evidence, such admission cannot be called in question at any stage of the suit or proceedings on the ground that the instrument has not been duly stamped. The division bench of Justice Sanjeev Khanna and Justice J.K. Maheshwari observed that objection as to admissibility of a document on the ground of sufficiency of stamp has to be raised when the document is tendered in evidence. In challenge to Section 64 Criminal Procedure Code, which mandates that if a person is not found, summons may be served by leaving one of the duplicates for him with some adult male member of his family residing with him, the Supreme Court has issued notices. The petitioner argued that the provision discriminates against women by treating them as outright incapable of accepting summons on behalf of their family members. The top court has also issued notices to the central government and the Attorney General in petition filed by a gay couple seeking recognition of same-sex marriage under the Special Marriage Act. The division bench, comprising of Chief Justice D.Y. Chandrachud and Justice Hema Kohli, heard the petition and issued notices at first instance. Primarily to gay men from Hyderabad has sought extension of right to marry a person of one's choice to LGBTQ+ citizens. Stating that Supreme Court has always guarded the rights of intercaste and interfaith couples, it has been prayed that it should continue the constitutional journey by including same-sex LGBTQ+ couples as well. In reiteration of ruling in Rahul S. Shah versus Jinendra Kumar Gandhi, the Supreme Court has directed district courts to dispose of all execution petition within a stipulated time period of 6 months from the date of filing. The division bench, comprising of Justice K.M. Joseph and Justice Hrishikesh Roy, while dealing with a special leave petition, observed that as far effect of the ruling, it become that the duty of the execution court to dispose of the execution proceedings at the earliest and can only be extended only by recording reasons in writing for such delay. The Supreme Court Division Bench, comprising of Justice A.S. Bopanna and Justice P.S. Narasimha, observed that the rights and duties of the parties to the contract subsist or perish in terms of the contract itself. Even if a party to the contract is a governmental authority, the court added that there is no place for discretion vested in the officers administering the contract. Discretion, a principle within the province of administrative law, has no place in contractual matters unless, of course, the parties have expressly incorporated it as a part of the contract. Next we have Delhi High Court. The Delhi High Court, while adjudicating on applications in a suit-seeking partition, has opined that trial within trial is not permissible. It thus observed that the scope of the suit shall be limited to ascertaining the rights between the original plaintiff and defendant and cannot be extended to ascertaining who will be the legal representative of the deceased party. The Delhi High Court has awarded damage to the tune of Rs 2 lakh and legal cost of approximately 13 lakh in favor of Starbucks in a trademark infringement suit over the mark Frappuccino, including brownie chips Frappuccino. The Delhi High Court has opined that Section 41 of the Narcotic Drugs and Psychotropic Substances Act A 1985 is a discretionary provision, and non-compliance with this provision solely cannot be a ground to grant bail to the accused. It was further held that non-compliance with the discretionary provision of Section 41 cannot absolve the accused from following the rigor of Section 37. The division bench of the Delhi High Court, comprising of Chief Justice Satish Chandra Sharma and Justice Subramanian Prasad, has upheld that National Medical Council's regulation limiting the number of attempts to clear first year of a MBBS course to a total of 4 and observed that there is no vested right of candidates to claim multiple attempts to clear an examination. The petitioner, who exhausted all his chances, had argued that the impugned regulations violates Article 14, 19 and 21, which the court turned down. The Delhi High Court has opined that a general power of attorney, which is undated, unsigned and lacks material substance, is non-est, and that solely based on it, no right, title or interest can be claimed in a property. It was held that no ownership can be conferred based on the agreement to sell. At best, it can be used to get the sale deed executed. The High Court further noted that the transfer of immovable property can only be done through a registered sale deed. The Delhi High Court has directed the Delhi government to pay a sum of Rs 16 lakh to a senior judicial officer to reimburse the expenses incurred on him due to COVID-19 treatment. The single judge bench of Justice Rekha Palli opined that the judge cannot be faulted or penalized for hospital charging amounts higher than what the government prescribed. The Delhi High Court has opined that substance of the agreement is relevant over the nomenclature used, and hence, when a clause used the word mediation but the feature resembling the arbitration clause, the clause would be considered as an arbitration clause. Now let's have an overview of other high courts. The Madras High Court has significantly held that cases under Section 12 of the Domestic Violence Act can only be challenged under Article 227 of the Constitution and not Section 482 Criminal Procedure Code in High Court. A full judge bench disapproved of the division bench's view and clarified that a magistrate court is a designated court to hear application under DV Act and nature of proceedings not being criminal. Petition under Section 482 CRPC cannot be maintainable. A single judge bench of the Punjab and Haryana High Court has held that if petition filed under Section 138 of the Negotiable Instrument Act stands withdrawn in view of an amicable settlement between the parties, continuation of proceedings under penal offences amounts to abuse of process of law. The Gujarat High Court has came down heavily on the state government and said that the compensation given to the families of those who died in the tragic Morbi Bridge collapse is abysmal. The court has held the municipal officer responsible and added that the compensation should be realistic and need of the hour is to give appropriate compensation. The Kerala High Court, while observing that enough sufficient space should be provided in jails so as counsel can speak with their clients privately, the court further issued directions to the concerned authorities to consider the possibility of granting space or considering other options like a rough sketch submitted by the District Legal Services Authority. The Bombay High Court has observed that as regard cruelty, it is important there is a reasonable apprehension in the mind of the party that living together would be harmful and injurious to life. Further, it was observed that for discretion, essential ingredients, that is the factum of the separation and animus discendi, needs to be proved. A single judge bench of the Madras High Court dismissed a first appeal pertaining to a sale deed matter where it was unclear whether the plaintiff deceived the defendant or defendant deceived the plaintiff. The court held that the burden of proof for contentions of the plaintiff lies on the plaintiff himself, and instead of picking holes in the defense case, the plaintiff must substantiate and prove his own contentions. Moving on to miscellaneous news. The Shadra Bar Association of Delhi in a recent notice has prescribed dress code for interns as there was apparently difficulty in distinguishing them from the advocates. The notice states that they now have to come in white shirts, blue coat and trousers from December 1st onwards. It has also been stated that if they fail to comply, their entry from court will be barred. Participating in the Constitution Day celebration event at Supreme Court, Prime Minister Narendra Modi has launched 4 digital court initiatives in the presence of CGI DY Chandrachud to mark the occasion. The initiatives include Virtual Justice Cloak, Justice Mobile App 2.0, Digital Court and S3WAS websites. Attorney General of India R. Venkata Ramani has urged the central government to rethink provisions providing for direct appeals from different tribunals as they are resulting in Supreme Court getting overloaded and reduced to small cause court. He has also sought placing of a litigation policy so as only complex legal issues reach courts and not every matter get converted into litigation. The President of India, Draupadi Murmu, has nominated Justice Sanjay Kishan Kaul, second senior most judge of the Supreme Court, as the Executive Chairman of the National Legal Services Authority. The Chief Justice of India has announced that 4 special benches will sit in the Supreme Court to hear criminal appeals, land acquisition cases, tax-related cases and motor accident claim matters. The state of Tamil Nadu has defended Jallikattu in Supreme Court, stating that it is a religious and cultural event celebrated by people of Tamil Nadu and its influence extends beyond the confines of caste and creed. The top court constitution bench is in process to examine its legitimacy. The Delhi High Court has granted bail to former managing director and CEO of Yes Bank Rana Kapoor in more than 400 crore money laundering case being probed by the Enforcement Directorate. The Arvind Kejriwal-led Delhi government will challenge the Supreme Court's order acquitting the 3 rape convicts in 2012 gang rape and murder case. In the end, we have international news. New Zealand's highest court has ruled that the country's current voting age of 18 was discriminatory, forcing Parliament to discuss whether it should be lowered. The case, which was going through the courts since 2020, was brought up by the advocacy group Make It 16, which wanted the age lowered to include 16 and 17 years old. A US court has sentenced Theranos founder Elizabeth Holmes to 11 years and 3 months in prison for defrauding investors in her new, now defunct, blood testing startup that was once valued at $9 billion. The US court has cleared the release of Donald Trump's tax returns to a House of Representatives committee, handing a defeat to the Republican former president who had called the Democratic blood panel's request politically motivated. In an interesting instance, a Frenchman has won the right to be boring at work after a court ruled his employer was in the wrong for firing him because he did not go out after work for after-work drinks with his colleagues often enough. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.